examination of international criminal justice, both from the history and its application, principles of fair trial, notions of removal of impunity, the advancement of certain aspects of gender law. More specifically, you mentioned to us that justice can't really be measured in dollars. So what price justice may be at a high dollar value, probably at a lower notion of bringing more fairness to certainly international criminal justice has taken away the opportunity for war criminals to walk free. The notion of deterrence is very, very important, but clearly can't be measured in that. I like the way you described the 17-year period as being long if you're 17 years old. I think that's appropriate. We're looking at this probably from the wrong perspective. But I think that's a fair summary of what you've given us, but that doesn't do justice at all to the level of actual engagement you've had, because the very breadth of your discussion with us is the direct experience you've had. I'll open the floor now for questions that you might have to ask.
Hi. I just want to talk a little bit more or ask you questions about the whole issue of the criticism that the ICC has faced, particularly with regards to Africa. With the criticism that the ICC has faced with regards particularly from Africa. What is your view on the proposal from the African Union to give the future African Court of Justice and Human and People's Rights the jurisdiction to try international crimes? And related to that, you mentioned the self-referrals. 3 of the cases are self-referrals about African countries, but whether it's a positive development, but there's also a negative aspect to it, and that is that it seems that the reason that states make the self-referrals is because they want to externalize their responsibility to carry out prosecutions themselves. So, in effect, the self-referral system is undermining the purpose that the ICC has set out with the principle of complementarity. I just wondered if you agree with that.
Well, thank you for both important questions. To do them justice, I need a couple of hours. But let me try and deal with them as briefly as I can. The African Union and some African leaders have said, look, it's enough of this Western-created international criminal court, which it isn't. We want an African court to deal with African situations, and the African Court on Human and People's Rights should be given individual criminal jurisdiction, so that these cases before the International Criminal Court could come before an African court. Well, let me say, if there was a credible, efficient African criminal court, I would support it. I've no doubt that justice should be done as close to home as possible. For people in Kenya and even in Darfur, The Hague is a long way away. Even for people in Bosnia, The Hague was a long way away. And one of the benefits of the Sierra Leone Tribunal was that it heard most of its cases in Freetown, in the capital of Sierra Leone. So justice should be as close, should be held, courts should be held as close to home as possible. Let me say too that I don't believe there'd be anything inconsistent with the Rome Statute or the whole raison d'etre for the International Criminal Court if justice was done closer to home. It's part of the complementarity system. But in order for it to work, you'd need the court to be fully operational and working. There's no point in just talk about this court. Africa has little to be proud of when it comes to the African Court of Human and People's Rights. Judges have been appointed for years. They've heard, I think, one minor case in a decade. So they're not too keen on justice that's not done by their own courts or not done at all. So I think, in theory, it's a very good idea for the reason I've mentioned. And if the African Union and African states can put their act together and set up such a court that will operate on an even-handed basis, then I would say full cheer, and let us do it. It's part of complementarity that you referred to. Many of you, I'm sure, know that the ad hoc tribunals had primacy, as it's called. We could choose which cases we wanted to hear. So when a man called Tadic was arrested in Germany, as chief prosecutor, I said, and I had the power to say, Germany, you are not to put Tadic on trial. We want him in The Hague before the International Criminal Court. And Germany had no option, didn't like it. It tried to resist it, but it had no option because it wasn't prepared to violate the Security Council resolution. And they had to pass special legislation in the German parliament to make it possible to transfer Tadic to the Yugoslavia Tribunal in The Hague. But they did it. The idea of the International Criminal Court is the converse. The International Criminal Court only has a second bite, not the first bite at the cherry. It's the idea of the International Criminal Court is that if countries are prepared to put their own nationals, their own citizens on trial, then the International Criminal Court has no jurisdiction. So if Kenya had decided to investigate the crimes alleged against Kenyans, the International Criminal Court would not have been able to get into the act. The court would have had to defer to the domestic tribunal. In any of these African situations, if there were courts willing and able to take on those cases at home, the International Criminal Court could not and would not have been able in law to have got involved in those cases. So it seems to me consistent with complementarity that an African court should do what maybe domestic courts are unable to do. If Kenya is unable because it's unwilling to investigate crimes committed by Kenyans in Kenya, if there's an African court that Kenya is happy with and will take over that responsibility, that's fine. And I don't think, as I say, it's any way inconsistent with the International Criminal Court. Luis Moreno Ocampo, the first chief prosecutor of the International Criminal Court, in fact annoyed the judges in his first public announcement. He said, and he was serious, he said, if I do my job properly and get countries to put their own people on trial, if I do my job successfully, there'll be no work for the International Criminal Court. The judges, I think, weren't thrilled to hear that if he did his job properly, they'd have no work to do. But of course, it doesn't turn out that way. But this complementarity system is a good one because it encourages countries to pass laws consistent with the Rome Statute, as South Africa has done. If a South African was charged with a war crime committed as a mercenary or in any way in a situation subject to the International Criminal Court's jurisdiction, our courts, our government will say, we will investigate our citizen, our national, and we will put him or her on trial in our courts, and that will drop the International Criminal Court of jurisdiction. I hope I've answered the second part of your question as well.
It was actually more about the self-referrals, the decisions by states to self-refer. If you look in the case of the Congo and if you look in the case of Central African Republic, one of the key motivations for the self-referrals is because they didn't want to do the prosecutions themselves. It was much easier for them to just shift the responsibility to the ICC rather than deal with the issue themselves.
Look, that's an additional problem. I think Ocampo was very keen to get the first self-referral from Uganda. And of course the referrals from Uganda and the CAR and the DRC, one must see them for what they are. Their leaders clearly used the International Criminal Court for political reasons. I don't believe that they were that they did these referrals for moral reasons. But it is arguable that Uganda couldn't put Joseph Kony and the leaders of the Lord's Resistance Army on trial. They couldn't get them. The International Criminal Court has been no more successful, but that's not the point. And certainly Ocampo, to the best of his ability, I believe, satisfied himself and had to satisfy the judges in the pre-trial chamber that those countries were not able to put these people on trial. So I think I can see their arguments, and quite frankly, I don't know the details of the internal situation well enough really to pass any opinion.
Was hand up.